good evening. My name is Jared Strauss, and on behalf of the Board of Student Advisors and Dean Kagan, I'd like to welcome you all to the Ames Moot Court Competition final round. Tonight's case, Amy Ennis et al. Versus the State of Ames and the Ames Department of Health, was written by Sean Spencer, lecturer on law and acting director of the first-year lawyering program. In tonight's case, the four petitioners are four same-sex couples challenging the Ames Defense of Marriage Act, claiming that the ban on same-sex marriage violates the U.S. Constitution's due process and equal protection clauses. The petitioners are represented by the Atticus Finch Memorial Team, which is comprised of Victor DiLorenzo, Ryan Hecker, Mark Crickbaum, Paul Saratella, Sergio Troy, and Lee Weems. Mark Crickbaum and Sergio Troy will present oral arguments. The respondents are represented by the Archibald Cox Memorial Team, consisting of Ramsey Ajami, Jonathan Ben-Lulu, Michael Block, Tom Liu, Sujit Raman, and Jamie Simpson. Tom Liu and Sujit Raman will present oral arguments. United States Supreme Court Justice Ruth Bader Ginsburg will serve as our Chief Justice this evening. Joining her are Richard A. Paez of the United States Court of Appeals for the Ninth Circuit and the Honorable Reena Raggi of the United States Court of Appeals for the Second Circuit. Please hold your applause until all the oralists have spoken, and remember that the petitioners will be doing rebuttal arguments after the respondents speak. You'll have the opportunity to take pictures of the judges when they first come in, but once oral arguments start, please refrain from taking pictures. Only the official law school photographer can take pictures. Also, at this time, if you could please all turn your cell phones and pagers off. Best of luck to both teams, and enjoy the arguments. We'll start in just a moment.
We are convened to hear the case of Amy Ennis et al. Against the State of Ames. And we will hear first from Petitioner, first from Mark Crickbaum. Mr. Crickbaum, please proceed.
Thank you, Madam Chief Justice, and may it please the Court. My name is Mark Crickbaum, and I represent the petitioners. They are two lesbian and two gay couples, each committed to a long-term relationship of mutual protection, love, and support. They are parents and grandparents, PTA dads and soccer moms, and each of them wants to be something more than merely a boyfriend or a girlfriend. They want to marry. But the State of Ames insists that it must defend marriage against the threat of the petitioners and their relationships. Ames is wrong. As my co-counsel will argue, the so-called Defense of Marriage Act unconstitutionally discriminates against the petitioners and violates the Equal Protection Clause. And as I argue, DOMA violates the petitioner's fundamental right to marry. This Court's decisions make clear that the right to marry is of fundamental importance for all individuals. Marriage creates and sustains loving, stable families, and this Court's decisions link marriage with devotion and intimacy. In Turner v. Safley in 1987, when this Court confronted the question whether the fundamental right to marry protects prison inmates, the Court did not first search for a tradition that protected the right of prisoners to marry, for no such tradition exists. Rather, this Court examined marriage itself.
May we go back then to this fundamental right to marry, which when our nation was new, was understood to be between a man and a woman. Indeed, husband and wife were one, and man was the one. It was a relationship of dominance and subordination. How do you get this fundamental right from a due process clause that was drafted at a time when that was the understanding of marriage, clearly a man and a woman? Where does it come from?
Well, Your Honor is quite correct. The definition of marriage has changed many times in our nation's history. And in 1888, when this Court declared that marriage is the most important relation in life, it surely was not considering interracial marriage, for example. That did not prevent this Court in Loving from finding that the right to marry protects interracial couples. This Court has never interpreted the Due Process Clause to protect only that liberty that was protected when the 14th Amendment was ratified. If that were the case, then this Court's landmark due process decisions would all have been decided the wrong way. When this Court protected the right, for example, to make choices about bearing and begetting a child, or about the right to have an abortion, or to choose sexual intimacy, this Court overturned tradition. And that is the history of the Due Process Clause.
Which case do you contend supports, do you rely on that supports your contention that there's a fundamental right? Loving?
Your Honor,
Which one?
The fundamental right to marry that protects interracial couples in Loving, that protects prisoners in Turner v. Safley, that protects the indigent in Zablocki, also supports the right of gay and lesbian couples.
Well, weren't the courts a little bit more concerned with race in Loving and with economic status in Zabalski? And weren't there other considerations involved other than just the right to marry?
Well, Your Honor, certainly Loving was about race, but this Court has made clear that it was about race and marriage. In Zablocki, this Court rejected the notion that Loving was merely about race. Although Loving arose in the context of race, this Court in Zablocki said that the right to marry is of fundamental importance for all people.
But in all those cases, the Court was thinking in terms of a man and a woman. And in Loving, which was a path-marking case, I think the Court made it clear that that was a case that might have had, well, we're all equally disadvantaged, white as well as black, but it was a notion of a superior race and an inferior race. And here, there's nothing that says that men or women, that one sex is superior or inferior to the other. So the Loving analogy, I think, falls short.
It's correct, Your Honor. This law does not discriminate on the basis of gender. Instead, it discriminates against gays and lesbians. In fact,
Mr. Crickbaum, could the state get out of the marriage business altogether and just not license anyone?
Your Honor, under the Equal Protection Clause, the state might be able to. Under the Due Process Clause, it cannot.
So your position is that states must license marriage.
That's correct, Your Honor.
And where does that derive from?
Your Honor, this Court makes clear in Loving, in Zablocki, and in Turner, and in Body against Connecticut, that the obligation of the state in the fundamental right to marry is to recognize marriages. That is what the state must do. Now, this Court has also recognized that marriage is the most important relation in life, and part of what makes that relationship important.
Well, isn't the state, what the state cannot do is intrude in the choices people make, as I understand your argument.
That is certainly part of what the state cannot do.
What is it that requires the state to endorse any choice about relationships?
Part of the reason that marriage is fundamental and part of the reason that it is protected by this court is that there is a difference between a private commitment, one that amounts to a boyfriend or a girlfriend, and a public commitment that is ratified by the state. The latter commitment is deeper and more significant. It also plays a more important role in people's lives. There's no way to make sense of what it means to have a fundamental right to marry.
Mr. Crickbaum, is this essential to your argument? You are arguing in a situation where the state does license marriage for most people.
Quite correct, Your Honor.
And the hypothetical that it might not license for anyone would be a totally different case.
It is a totally different case, and no states are lined up to abolish marriage. That is simply not a political reality, and Ames has never suggested that that's what it wants to do.
But you've asked us to take our Constitution and import into it this fundamental right to marry, equally available to anyone. And I asked you before where you get it from, and you say certainly it was not the original understanding. If it's the understanding that has grown among the people, why should it not be the people's choice through their elected representatives? Why should a court of unelected judges make the decision about what is right for the contemporary society?
Your Honor, under our constitutional system, it is the function of this court to enforce and protect fundamental rights. This court made clear in West Virginia against Barnett that fundamental rights may not be submitted to a vote. They depend on the outcome of no election. And in fact, in Loving, a majority of the population, national polls showed that even a year and a half after this court decided Loving, 72% of Americans opposed interracial marriage. This court chose, to its great credit, not to ratify that public sentiment, but rather to recognize that marriage is fundamental for interracial couples, and we suggest also for gay and lesbian couples. Additionally, if you look at this court's landmark decisions—
Would your client's fundamental rights be adequately protected by state recognition of civil unions as occurs in some other states?
Well, Your Honor, certainly that raises a much different issue than this case.
I'm asking these questions because I'm interested in whether you do have a fundamental right here and whether it has to be called marriage.
I understand, Your Honor. And the Constitution protects the fundamental right to marry. Civil unions are not marriage. Marriage light is not marriage. And there are no separate institutions with asterisks in our culture that serve as a substitute for marriage. The state of Virginia, we believe, could not have created civil unions for interracial couples. The state of Missouri could not have created civil unions for prisoners. Our Constitution protects the right to marry. Now,
is there any limit on this fundamental right?
Certainly, Your Honor.
In other words, if the state of Ames had to recognize same-sex marriage, what about polygamous marriages?
Well, polygamous marriages—
Or first cousins.
Well, first, Your Honor, laws banning polygamy do not infringe on the fundamental right to marry. I have a right to marry, not to marry an infinite number of people simultaneously. So that raises a different issue.
Well, the Bible thought so.
The Bible did think so, Your Honor, but—
And it's got a tradition longer than the one you're asking us to endorse as fundamental.
That's true, Your Honor. It remains true, however, that a polygamist is already married. He has his fundamental right to marry. Additionally, even if laws dealing with polygamy were subject to strict scrutiny, they would probably
So where would we draw how would we draw the limiting principle?
The limiting principle, Your Honor, is
with this fundamental right?
Certainly, laws that impose a direct and substantial barrier on the ability to enter marriage for an entire group or nearly all members of that group. That's what this court held in Zablocki.
Why do you say nearly? Isn't it all members?
Well, in this case, it is at least a near total exclusion for all gays and lesbians, Your Honor, and certainly it's a total exclusion for anyone who wants to have a same-sex union, yes.
Why don't you tell us what your definition of marriage is so that we make sure we are clear on what the fundamental right you're asking us to endorse is. What do you say is a marriage? You don't think it's polygamy?
Well, we don't have guidance from the state of Ames. They don't define marriage. This Court's decisions...
What's the fundamental right?
This Court's decisions, Your Honor, have linked marriage with intimacy and devotion. So in Turner...
Among other things,
Certainly
correct?
among other things. However, those are some of the most important attributes. In Turner, this Court talked about public support, personal dedication, and emotional commitment as being at the core of marriage. Certainly, those are things that gay and lesbian couples can participate in and want to participate in just as much as straight couples. Indeed, Amy Annis and Barbara Batson have been committed to one another for 24 years. They have raised 2 children and 3 grandchildren. Their devotion is not in question. Marriage is fundamental because of the commitment the partners make to one another.
Why does it take an act of the state, though, to ensure that or to allow that to happen?
Well, the act of the state, Your Honor, is to recognize that relationship. And in this case, what the state of Ames does...
But the relationship you described could be one that a same-sex couple could achieve without that recognition.
But it's not the same. It's the difference between a private relationship that 2 people talk about amongst themselves or maybe even amongst their friends and a public relationship that the state has recognized. This Court in Lawrence said that the state must respect the enduring personal commitments of gay and lesbian Americans, and instead, the state of Ames tells them that they are incapable of marriage, that they cannot love in the same way as their straight friends, and in fact, that their relationships are inherently incomplete, adolescent, and inferior, that maybe they can be boyfriends and girlfriends, but certainly they cannot marry. That is unconstitutional.
And you're asking us to interpret all of those negative statements by the state from the fact that marriage is not allowed.
Well, Your Honor, the state tells them that they cannot marry.
Right, but you suggested that they've labeled their relationship adolescent and a number of other pejorative adjectives. That you're asking us to infer all those pejorative comments on marriage, on the relationship, from the fact that it will not be labeled marriage.
Your Honor, we're asking you to infer that from the fact that the state excludes gay and lesbian couples, whereas it allows heterosexual couples who are similarly situated to marry. What that must mean is that the state thinks that gay and lesbian couples simply aren't capable of marriage. Otherwise, they could marry.
Well, so
Mr. Crickbaum, if I may return to the question of who decides, you did cite in your brief in support of this fundamental right the understanding of other countries. I think you said that many other countries allow same-sex marriages.
That's correct, Your Honor.
But apart from Canada, in certain provinces, I do not know of other countries where the approval has come from a court or the requirement has come from a court rather than the political branches of government. Do you know of any such case?
Your Honor, my understanding is the same of yours, that in most of Northern and Western Europe, these changes have come through the legislature. Now, there are a number of courts who have considered and are continuing to consider these issues. A case is forthcoming before the European Court of Human Rights, and certainly Canada is an example where the court brought about the marriage relationship. However, the issue in this case is not whether it should be the legislature or the courts. This court has settled that issue in a number of prior cases. It is clear that this court protects and enforces fundamental rights. The question is this such a right? And this right is similar to many rights the court already protects for gay and lesbian Americans. This court protects their right to make choices about sexual intimacy. It protects their right to make choices about whether to have a child, about how to raise their children.
Is there any difference in your fundamental right analysis between the state not intruding in these choices and the state being told it must endorse and give a license to the choice? Is there a difference at all for you?
Well, Your Honor, this case is about state interference. The state of Ames tells the petitioners that it eliminates half the population from their marriage choice and dictates that they may never marry the person they love. That is a devastating interference with their lives. It is one we would never allow the state to inflict on heterosexuals.
But it does not interfere with their ability to establish a household, maintain the intimacy of the relationship. That's been taken care of already through the law. Isn't that correct?
They can form relationships, Your Honor, but they cannot form marital relationships. What they seek is the certainty and stability that marriage brings, and Ames turns them away at the door.
Mr. Crickbound, I think you would want to finish up now because your time is almost expired.
Yes, Your Honor. This court in Lawrence held that the state has an obligation to respect the enduring personal relationships of gay and lesbian citizens. The state cannot respect that relationship when it treats it as inferior to the marriages that, for example, convicted criminals can enter into. The petitioners in this case have exhibited their dedication, and the state of Ames should respect and recognize their relationships. Thank you.
Thank you, Mr. Kirkbound. We will hear now from Mr. Troy, is it? Please proceed, Mr. Troy.
Thank you, Madam Chief Justice, and may it please the Court. My name is Sergio Troy, and I represent Amy Annis, Barbara Batson, and the other three couples before this Court. Ames's Defense of Marriage Act, or DOMA, is irrational. It categorically and irrationally denies gay and lesbian couples and their children the rights and responsibilities of marriage, thereby violating the Equal Protection Clause of the 14th Amendment. DOMA is irrational precisely because it supposedly was intended to promote child welfare. Yet, as Ames concedes, DOMA works unfortunate disadvantages to certain individual children. It is irrational to promote child welfare while disadvantaging children. Assuming for the time being that DOMA does not infringe upon a fundamental right to marry, it must still bear a rational relationship to a legitimate state purpose. This is the essence of rational basis review, and is a review that DOMA must fail. Rationality review is not a monolithic test. Though generally this court is deferential to economic regulations like licensing of opticians or cable franchises, the court does not always apply kid gloves to rational basis cases. In fact, there are several considerations this court takes to decide whether it employs a more searching form of rational basis review. One of these considerations is when a law significantly and directly burdens a personal relationship or interest, or when a law categorically denies a group of people important legal protections or benefits.
Without rising to the level of a fundamental right.
Without rising to a level of fundamental right, but still something of importance. And also when a law singles out politically unpopular groups for disfavor. Now, in the past, when this court has considered these issues, it has struck down laws under rationality review in cases like Moreno, Cleburne, Plyler, and Romer, as well as Eisenstadt. What we are fundamentally arguing is that our case, a case of state denying gay and lesbian couples recognition, is much more like the denial of anti-discrimination protection to gay and lesbians in Romer than the licensing of opticians or of cable franchises. Now, the state of Ames...
Well, the Romer case was about denying people access to the political process. How far can that get you when the political process is open to you? You can convince the state legislature. That was the disability in Roma. A class of people were told you don't have access to the political process. You stop behind the 8 ball. But that you are free to, your clients are free to appeal to the legislature to make this change?
That's right, Your Honor. However, in Romer, the gay and lesbian individuals could lobby to have the state constitution be changed. So in that sense, they still had access to the political process, as Justice Scalia pointed out. It's just that it was much more difficult than it would have been before in that case.
And here it's not more difficult.
That's right, Your Honor. It's just it's a statute in this case versus a state constitutional amendment in Romer. However, there was still opportunity through the legislative process to change that in Romer. Yet this court chose, in the case of Romer, to strike down Amendment 2 in Colorado as a violation of the Equal Protection Clause under rational basis review.
Under rational basis review, but you used the expression with bite. And in your brief, you developed a distinction that I must say slipped from my grasp, and that was the difference between what you call specific acts on the one hand and categories of activity. I didn't understand what falls into one group and falls into the other. and what difference it makes, whether it's a specific act or a category of activities.
I'm not sure what specifically Your Honor is referring to.
Your brief said that there is a distinction between specific acts, and you gave two examples, marriage and travel, and then you gave categories of activity, family life, child rearing, procreation, and sexual intimacy. I couldn't understand why you made that distinction. I think you now have these nice printed briefs, but it was in the briefs.
I think Your Honor is referring to a portion of the brief discussing the fundamental right to marry, not the portion on equal protection challenge with rational basis review.
So you're assuming that if there is no fundamental right, then we have to evaluate this applying rational basis review.
That is our argument, Your Honor.
It was this distinction between specific acts and categories of acts, and I don't understand where that comes from.
That distinction is not relevant to the rational basis portion of the argument, Your Honor.
It's on page 17 of the briefs that we were given.
Right. That's the first portion of the brief, which deals with the fundamental right to marry and the substantive due process challenge to the state DOMA.
So you are saying that distinction between specific acts and categories of acts you really...
It's not relevant to our discussion of rational basis.
Then may I ask you, is it relevant to anything, or is it just confusing?
At this point, it appears to just be confusing, Your Honor.
Please proceed with your argument.
I mean, don't you contend that there is a rational basis with a bite or heightened rational basis review at play here? Isn't that your argument?
That is our argument.
Or is it just, or are you just relying on straight rational basis review? And does it make a difference?
It may not make a difference, honestly.
And do the cases even recognize the difference between heightened rational basis review and rational basis review?
Your Honor is quite right. The cases do not, in any holding, actually say this court has not held we are applying heightened rational basis review or rational basis with teeth. However, when you look at the procedure, the methodology this court has employed in cases like Moreno, in cases like Cleburne, it is not the sort of hands-off, highly deferential review applied to economic regulation. The court has invalidated, for instance, in Eisenstadt, a law that was substantially over and under-inclusive, which would not be a result that would be consistent with ordinary rational basis review.
Let me ask this. Whatever review we apply, what we're looking for is to see whether there are principal distinctions between heterosexual and homosexual unions, correct?
That's correct, Your Honor.
Now, some commentators have suggested that the state licenses marriage to regulate heterosexual behavior in order to bring some order to procreation. That's not a problem in same-sex unions. So to that extent that there's a different problem being addressed, why can't the state have more of an interest in bringing order to that type of union because of its potential for procreation and the problems that would ensue when it doesn't have those problems with same-sex unions?
Well, Your Honor is quite right that the state has an interest in procreation. However,
not an interest in procreation, an interest in bringing order to the process of procreation and establishing stability and some kind of sense with respect to the obligations in that arena where the union itself has the ability for the procreation.
Well, Your Honor, just on the issue of procreation in our day and age, the link between marriage and procreation has become quite attenuated. In America today, almost 50% of married couples cannot naturally procreate, either because they have undergone voluntary sterilization or are infertile. And indeed, 100% of couples where the wife has passed the age of menopause cannot naturally procreate. This is somewhere in the order of 10 times as many married persons who cannot procreate as gay and lesbian couples in America.
But we don't need the specific fit if we're doing rational relationship. It nevertheless remains the only union that has this risk of illegitimacy.
Your Honor, while in most rational basis cases, a specific fit, a scientific fit, is not required, what this court found that in cases where a law is riddled with exceptions, such as in Eisenstadt, where the issue was a contraceptives law that could be avoided if you said you were getting the contraceptives for health purposes as opposed to contraceptive purposes, or where the single person was going to have a sexual liaison with a married person, and that married person had access to contraceptives. When a law is so riddled with those sorts of exceptions, it falls under a slightly heightened basis of rational basis review. Similarly, in this case, the fact that it's an incredibly poor fit between who can procreate and who's allowed to marry would similarly indicate that there's no rational basis to deny marriage to gay and lesbian couples simply on the basis of natural procreation.
What is the class or group that you think is being treated in a discriminatory manner by the Ames law?
This class or group are same-sex couples, which, as a social reality, are almost 100%, if not 100%, gay couples and lesbian couples.
May I ask you just, you were very careful to say in your brief, and both of you at the argument, near exclusion of gay and lesbian couples. Well, now you just said less than 100%. Who are the people who would be included who are gay and lesbians?
I'm sorry, who would be people who are included?
Because you say near, not total exclusion. I thought you would say that same-sex couples are totally excluded, but you say near excluded, less than 100%. What is the included portion, however small it may be?
The same-sex couples, all same-sex couples are excluded. What we're trying to point out, there may be technical instances where two persons who would not otherwise have a homosexual orientation might enter a same-sex union. This highly implausible scenario is why we hedge our words. And similarly, there are instances of gay and lesbian individuals who choose, for whatever personal reasons, not to enter a same-sex union, but to marry a member of the opposite sex. Furthermore, not only is procreation a superbly bad fit for DOMA, but also on the issue of child rearing, DOMA seems to be an incredibly poor fit. And indeed, it is entirely under-inclusive in the sense that DOMA disadvantages thousands, if not tens of thousands of children. These are children raised by same-sex couples, gay and lesbian couples in Ames, while the state of Ames can identify no group of children that are somehow shifted into an environment where they're raised by one man and a woman, which is what the state of Ames claims to be the optimal setting for child rearing. This kind of disconnect is precisely what should cause this court to strike down DOMA on rational basis review alone.
But you recognize that the literature takes different views on child rearing in same-sex and heterosexual relations, correct?
I do, Your Honor. However, as the record indicates, and as the state of Ames has stipulated to, they've stipulated to studies that say and argue conclusively that there are no conclusive studies of gay parenting one way or another. We simply do not have enough data. The data is limited by small sample size or by an unrepresentative sample. Thus, the idea that there exists somewhere out there evidence, hard proof, that gays or lesbians are bad for children in some way is just a myth.
Well, the fact that Ames allows adoption and suggests that it approves it, but you're saying it can't say that on a ranking it would prefer heterosexual families. Your position is it cannot do that and simply suggest that rather than have a child in welfare or foster care, it will certainly agree to same-sex adoption, but its preference is for heterosexual families. Your argument is that that violates equal protection?
Well, for several reasons, Your Honor. First, for the first reason, this principle is dangerous. It has legs. If we imagine that this court can ratify the state of Ames based on no evidence, just sheer speculation that there are certain classes of parents that are better than others, what does it stop them from calibrating benefits based on whether someone is poor, uneducated, not a native English speaker? In all of those cases, it is highly plausible that the children of those parents will fare worse in some measure than the children of other parents. This is a perverse outcome. Secondly, if the reason that the children of gay and lesbian couples fare worse in society is because they face the discrimination that is directed towards their parents, that is not something that this court can take cognizance of. In Palmore v. Sidoti, this court faced a similar situation in the case of a custody dispute where a white woman had remarried a black man, and in that case the court decided that it could not ratify private prejudice even though that child may indeed face a higher level, a more difficult life than if she had stayed with her white father. Similarly, in this case, the court cannot ratify any sort of speculative prejudice against gay or lesbian parents without anything more.
Do you get something more from marriage for these children than you do by adoption?
Certainly, Your Honor. What marriage provides for them is the security of knowing that if their parents, one of their parents dies, for instance, there are certain default rules for inheritance. If their parents were to split up, for instance, there would be the court would look out for their welfare through an equitable distribution of property. All of this has been established already in law. Now, what gay and lesbian parents have to worry about is work through private law in order to order their affairs in order to reach these results. And none of this assures that they will do so and therefore benefit their children.
Mr. Troy, I'd just like to go back to one concern that Justice Ginsburg raised, and that is, our tradition in this country is not on your side. And if you look at these 8 reasons that the state proffers here, if we go down each one, we could probably make good arguments why each one is irrational or not, should not be used to justify the discrimination that you're challenging here. But don't these reasons, sort of taken together, reflect that tradition that Justice Ginsburg referred to, that the legislature has recognized in adopting the statute? And why should we say that the reasons that they proffer here are insufficient?
Your Honor, tradition by itself, if that means doing something for the sake of doing it because you've always done it, is not a rational reason to do anything. As Justice Blackmun noted in his dissent in Bowers, he said, "It is revolting to have no better reason for a rule of law than it was laid down in the time of Henry IV. That is why it is irrational to continue to ban same-sex couples from marriage simply because that is the way it has always been."
Mr. Troy, I think your time has expired.
Thank you, Madam Chief Justice.
We will now hear from respondents. And first, Mr. Rahman. Mr. Rahman, please proceed.
Madam Chief Justice, and may it please the Court. The petitioners in this case are asking this Court to transform society's bedrock institution. My colleague, Mr. Liu, will address their equal protection claim and explain how the Defense of Marriage Act rationally furthers the state's interests. I will argue the fundamental rights due process aspects of this case. Your Honors, under due process, this Court could evaluate petitioner's claim in one of 2 ways. First, the petitioners could be asserting that the established constitutional right to marry includes the ability to marry someone of the same sex. Now, in evaluating this claim, this Court should look to its prior precedents, cases like Loving, Skinner, and Zablocki. Alternatively, petitioners could be asserting a new fundamental right. In evaluating that claim, this Court should apply its established method for examining novel substantive due process rights, the test laid out in Washington against Glucksberg. And we submit under either approach, petitioner's claim should fail. I'd like to begin with the first point.
Well, if you read those cases that you just listed there, you come away with the feeling that the Court has recognized a fundamental right to marriage.
Your Honor, there's no question that there's a fundamental right to marry. But I'd like to focus on some of the things that Mr. Crickbaum said, because the way he interpreted Loving and Zablocki is, frankly, contrary to what this Court has held. Whenever this Court has discussed a right to marry, it has done so in the broader context of procreation, child rearing, and developing the next generation. In early cases, like Meyer against Nebraska and in Skinner against Oklahoma, this court made explicit the link between marriage on the one hand and the production and the upbringing of the next generation. Indeed, in Skinner itself, this court
So
observed-
unless the state is attempting to limit or restrict this right, this fundamental right, there is no fundamental right?
No, Your Honor, I think certainly that the right to marry exists as a freestanding right under the Due Process Clause, as acknowledged in Loving and in Zablocki. It's a fundamental right, just like any other unenumerated right.
Without regard to procreation, because otherwise the state could ban women from the age of 60 or perhaps earlier from ever marrying, and we know that that is not.
Certainly, Your Honor. If your question is why do we allow sterile couples to marry, certainly under the Due Process Clause, I think it's important to note that the link is not just, and as you suggest, Madam Chief Justice, it's not that marriage equals procreation. It's simply that marriage implicates broader concerns, like procreation and child rearing.
But
That is the-
marriage is licensed by the state, and no doubt you might agree that it would violate a fundamental right or equal protection to say that people over the age of can't marry.
Well, Your Honor, certainly the right to marry exists under both the Due Process and the Equal Protection Clause. But as this Court has held, whenever the state has a civil monopoly over an institution, it has to ensure that there is equal access provided. And that's the principle of cases like Harper. And that's exactly what this Court was doing in Loving and in Zablocki. It was assuming that the fundamental right to marry is what it has always been, the right to enter into an institution with a person of the opposite sex so that you can create the next generation and bring up the next generation.
But when we started down that road, it was at a time when sexual relations legally only existed within marriage in most states. That's not at all the situation anymore. Don't we have to deal with the reality of what's changed about that link that you want us to see as inextricable between procreation and marriage?
Your Honor, I think an important point to note is that it's not, again, that marriage equals procreation. It's simply that marriage implicates broader concerns. And I think, as to your point about whether or not marriage, whether circumstances have changed, I think it's important, again, to note that when this Court has addressed the right to marry, it hasn't just focused on procreation. It has talked about bringing up children and making sure that society regenerates itself.
Well, society has interests beyond that, doesn't it? I mean, marriage laws ultimately trigger a host of other laws about property, about evidentiary privileges, all of which pertain regardless of whether there are any children involved.
That's true, Your Honor.
All right, if that's so, why isn't there the same interest in the stability and orderly understanding of property among same-sex couples who choose to have the kind of commitment that is implicated in marriage?
But, Your Honor, it seems to me that's a slightly different question. The question is, under the Due Process Clause, what is the right to marry? And my submission is that whenever this Court has talked about the right to marry, it has done so in the context of opposite-sex couples, because whenever it has discussed that right, it has done so, as I suggest, in the broader context of procreation and child rearing. The petitioners try to reduce
So there's only a
marriage.
fundamental right for opposite-sex couples to marry?
Your Honor, that's not correct. Everyone has
Well, that's
a
what you just
fundamental-
said, wasn't it?
Not quite, Your Honor. Everyone has the right to marry. And that's the principle of Loving and Zablocki. That is, when the state has a monopoly over an institution, it has to make sure that everyone has equal access to it. And I can't emphasize enough, Loving was primarily, and Zablocki exclusively, an equal protection case. The underlying right, the right to marry, was the traditional notion of the right to marry between a man and a woman. And what the state did was say, these kinds of classifications based on race, classifications based on economic status, are not permissible. And the fact is, the underlying right, the right to marry, was what we've always thought it to be.
So
And
did Loving apply strict scrutiny because there was a fundamental right at stake or because the race was at stake?
Your Honor, I think there were both elements. That is, there was a fundamental right at stake, as well as the fact that race was officially a statute that took race into account. I think Loving was decided on both equal protection and due process grounds. Judge Raggi, if I could get back to a point that you made, in asking me about marriage and procreation and how history and times have changed, I think what the petitioners are asking for in this case is a fundamental redefinition of marriage based on, as you suggest, changing historical trends. And saying that now marriage is just about two people. And Mr. Crickbound used that term himself, devotional intimacy between two people. And I submit that is not what marriage is exclusively about. I think about this court's opinion in Griswold, the last paragraph, when Justice Douglas, writing for this court, said, marriage is a bilateral loyalty, a harmony in faiths. Now, those are powerful words. But yet, 2 years later, when this court recognized the right to marry, as it did in Loving against Virginia, Griswold does not appear once. Loving cited Skinner. And when it cited Skinner, it said, marriage is one of the basic civil rights of man, fundamental to our very existence and survival. That is the right.
You agree that the appellants have a fundamental right to choose with whom to be involved in an intimate relationship?
Certainly, Your Honor. Under
Okay.
Lawrence, the state simply cannot intrude on that private associational choice.
The state sanctions one particular type of choice for an exclusive relationship, that between a man and a woman.
Yes.
You're conceding it cannot prevent the choice between same-sex couples.
In the private
But you're
sphere.
saying it can deprive them of the legal recognition that then triggers a whole host of other benefits.
Your Honor, as my colleague will suggest, the way the statute has been written, it advances a legitimate, rational purpose. There are other interests involved here. There's an interest in procreation. There's an interest in child rearing. So the point is to make sure that children are brought up in an ideal environment and that procreation is encouraged.
How do you pursue the ideal environment given that you approve adoption for same-sex couples?
Your Honor, I think that's a question of looking at things from which perspective that you look at it from. With regard to the question of adoption, I think the state is looking at it from an ex-post perspective. That is, if we have children in the world who are in a bad situation, and the choice is between an orphanage or between living with the same-sex couple, the state endorses that choice. But looking at it from an ex-ante perspective, that is, if we're looking at a blank slate...
How about instead of post and ante, we look at it from the child's perspective? After all, adoption is about children, and child rearing is about children. And why doesn't it obviously disadvantage the child if his or her parents can't be married, as distinguished from other children in the class?
Your Honor, I think the answer to that question is simply a point about overbreadth. That is, it's a very small percentage of children who are actually in that position. And that's a question of, as my colleague will address more in the equal protection aspect of this case, that's a question of overbreadth. And it can sometimes lead to not the best situation, but it's a very small percentage of overbreadth. But I'd like to return, if I may.
Well, I don't understand the answer that you just gave me. I think what you said, it's all right if every child adopted by a same-sex couple is disadvantaged against every child that is born to or adopted by a heterosexual couple. You just said that, and then you said it's the minimum overbreadth. It seems to me it's total, that every child adopted by a same-sex couple will be disadvantaged vis-a-vis a child born to or adopted by a heterosexual couple.
Your Honor, again, I think that's a question of legislative power. That is it rational for the state to draw the line in the way it has? And under rational basis review, the state has legitimate interests in creating an incentive process, as I suggest, from the ex-ante perspective, how it wants to order society, and once it deals with children who are already born from the ex-post perspective. But if I may return to the question of the constitutional right to marry, and I think this is a very important point. Petitioners relentlessly try to reduce marriage, as I said before, to simply a relation between two people. And the way this court has addressed that question has never been that marriage is simply about two people. It's about the purpose of marriage in our society. When we want to, from the perspective of a social planner, if we're looking at it from a blank slate, I want to make sure that my society survives. And the first thing I do is identify the relevant unit that will do the reproduction, and that's an opposite-sex couple. And then I want to encourage that couple to bring up children in a safe, healthy environment. That's why marriage is fundamental under our Constitution. And every time this court has talked about the right to marry, in early cases to its most recent cases.
But if what you say is so, if a legislature just dealing with this rationality standard decided, yeah, that's what we really mean by marriage, then it would be perfectly permissible for the legislature to exclude all people who cannot procreate from marriage license.
Your Honor, I think that raises a very, to be candid, I think that raises a difficult question. Now, if the question is, can the state draw a statute such that it says sterile people can't marry, I think that would raise a host of other issues, other constitutional concerns. That is, there's a right to privacy implicated. Even on the very fact of the marriage license, that they ask you, are you sterile or not?
But why right to privacy? What you say is you've made a distinction between an affirmative right you're asking the state to give to a negative, the state shouldn't tread on my personal relationship. Why doesn't it work the same way if we're talking about two people of opposite sex who cannot procreate?
Is your question, Your Honor, why is this different from a private-public perspective?
Yes, wouldn't it be equally open to the legislature to restrict marriage to people who are capable of procreating?
Well, Your Honor, I think, again, that would not only raise privacy questions, but it's also a very difficult statute to draw in a narrowly tailored way. A lot of people, when they apply for marriage licenses, don't know if they're sterile or not. And certainly some people who think they are sterile, that is, if someone has a vasectomy or whatnot, that may not be a permanent condition. So I think the question of narrow tailoring is also a very difficult one in that specific context.
So you're saying that if you had a heterosexual couple who pronounced plainly and loudly that they did not ever intend to have children, and you had a same-sex couple that said that they intended to take advantage of surrogate parenting, in vitro, whatever, but they definitely intended to have children, the first would have a right to marry, the first couple, and the second would not.
Well, Your Honor, yes, but to address your point, the first point, if I may, the first point with the first couple, they have a privacy right. That is, it's up to them, under the principle of Griswold against Connecticut, to decide when and how to procreate. So that's not the issue. The second point, though, is if a same-sex couple is determined to have children, whatever it is, that relationship will always implicate a third party. That is, when two same-sex people are in a relationship, they must go to a third party if they're going to have children. And that, from the state's perspective, is not an optimal condition for which children under which children can be born. So I think that's my response.
But that pertains to many heterosexual couples who choose to procreate that way with the assistance of a third party.
That's correct, Your Honor. But again, because for other reasons. That is, the state's second asserted interest is that it's an optimal condition for childbearing. So a heterosexual couple that adopts a child is fulfilling the state's interest in a way that same-sex couples do not. I'd like, if I may, Your Honor,
Mr. Roman, just let me ask you one.
Please.
You made a comment earlier that all that the petitioners were seeking here was just marriage between two people.
Your Honor, I think
it's much more than that, isn't it? I mean, their argument is far deeper than that.
Your Honor, I think what the petitioners are saying is that the fundamental right to marry.
The record here shows familial relationships.
There's no question of that. That's quite true, Your Honor. But I think, again, what's important to note is what they're saying is that this court's recognition, the constitutionally recognized right to marry, is simply a question of devotional intimacy. And I submit to the court that that has never been what this court has said in relation to the right to marry. It has always linked that right, not as being something between two people, but as something serving a larger social function in creating the next generation and making sure that next generation is brought up in a safe, healthy environment. If I may, I know I'm running out of time, Your Honor, I'd like to quickly just address the question of Lawrence, because I think Lawrence does bring up a very host of interesting questions. The fact is, Lawrence was fundamentally about criminalizing private consensual behavior. Now, the DOMA doesn't do that. The DOMA is not a criminal statute, it's a civil statute. And it doesn't intrude into the privacy of the home. It's simply a public institution that puts forth the values of marriage that have been recognized by society and by this court since the very beginning. So when the petitioners...
Do you think DOMA has any stigmatizing effect?
Your Honor, I think that what the DOMA does do is put an emphasis. It puts heterosexual couples sort of at the top for the asserted reasons, for the reasons of procreation and childbearing, and it has legitimate, rational reasons to do that, as the empirical studies that I know my co-counsel will refer to cite.
What's the reason on labeling optimal child care if you allow children to be adopted by same-sex couples? I'm concerned that I may have understood your argument to suggest that it's okay to tell the children who are adopted by same-sex couples that they're in a second-rate family.
If
Your
you
Honor,
could do
it's-
that in one sentence, because your time has expired,
Okay.
Mr. Rahman.
Your Honor, if I may indulge the court, I think it's, again, a question of once the child is born, it's not what we're telling the child. We have the child's best interest in mind if the choice is between an orphanage or being brought up by a same-sex couple. Thank you very much.
Thank you, Mr. Rahman. We'll hear now from Mr. Liu. Mr. Liu, proceed whenever you're ready.
Thank you. Madam Chief Justice, and may it please the Court, the Ames Defense of Marriage Act is constitutional and does not violate equal protection because the statute rationally furthers legitimate state interests and thus, contrary to Petitioner's claim, was not motivated by a bare desire to harm gays and lesbians. Your Honors, the proper standard of review to evaluate DOMA is rational basis review. As my co-counsel just argued, DOMA does not infringe upon a fundamental right. DOMA also does not classify on the basis of a suspect or semi-suspect class. Indeed, petitioners make no such claim in their brief. Instead, petitioners want this court to apply so-called heightened rational basis review.
Before we get to heightened rational basis review, you did say in your brief, you said this is not a suspect classification, it's not semi-suspect, and then you said such as. And in suspect classification, you gave such as race. Is there anything else that fits into that category?
Yes, Your Honor. Race, alienage, and national origin are all suspect classes, as this court well knows, and also semi-suspect classes include gender.
So you can deny Social Security benefits for an alien because it's a suspect classification, but that doesn't really matter? I'm thinking of the Diaz against Matthews. You said alienage is a suspect classification.
That is correct, Your Honor.
And I'm asking you, well, what cases you base that on?
Your Honor, I don't have the cases in front of me for alienage.
Well, you might inspect the court's performance. It's, I think, at least doubtful whether alienage fits that category. So you gave us race and national origin.
Yes, Your Honor.
So that's such as 1+. And then you gave us for semi-suspect sex and out-of-wedlock birth. Is there anything else?
Your Honor, to my knowledge, this court's semi-suspect classification has been restricted to out-of-wedlock births and women. And the point I'd like to make here...
Sex, gender, men as well as women.
Yes, Your Honor. My mistake. Sex discriminations, Your Honor. Sex-based classification.
But I was just wondering when I got to that point in your brief why you didn't say i.e. instead of such as, implying there were many more.
Your Honor, that was probably a decision that we now know better not to do in the future. Your Honor.
Now, please go ahead. You
Yes,
wanted
Your
to
Honor.
tell us about rational basis review.
Yeah, with respect to petitioner's claim about heightened rational basis review, they say that when a classification impinges upon important personal interests and relationships, or when it targets a politically unpopular class, that this court should apply heightened rational basis review. And what I'd like to draw the court's attention to is this is remarkably similar to what this court did in the Plyler v. Doe case. The language of important personal interests and relationships it's basically a code word for saying not quite a fundamental right, kind of like a quasi-fundamental right. And with respect to targeting a politically unpopular group, that's kind of like saying, well, they're not quite a suspect class. So what this court in Plyler did was take a kind of fundamental right and a kind of suspect class, put them together and say intermediate scrutiny should apply. And that's essentially what the petitioners are arguing for in this case. However, as this court itself has implicitly suggested by cabining Plyler to its specific facts in the case of Cotter-Moss v. Dickinson, that type of analysis does not have any cabining principles that this court's traditional equal protection jurisprudence has. It essentially makes this court decide whether to apply heightened review on an ad hoc case-by-case basis. And therefore, we urge this court to apply traditional principles.
And are you asking us, in other words, to overrule Plyler and Claiborne and Moreno?
Certainly not, Your Honor. The point about Plyler I'm making, Your Honor, is that it does not contain the kind of cabining principles that traditional suspect class, this court's traditional suspect class jurisprudence has. Plyler has been specifically confined by this very court to its unique facts. And, Your Honor, the broader point I want to make here is that heightened rational basis review just is not the appropriate review standard to use in this case. If this court wants to talk about heightened scrutiny, we can talk about semi-suspect or suspect class. But heightened rational basis review it's a standard that this court has never announced, and it's not cabined, and it allows this court to essentially usurp the role of the legislature whenever it feels like there are important...
It has never announced, but now you've canvassed so many of our equal protection cases. Can you honestly say that rational basis is, as the Chief said in the Fritz case, ever and all the same, that it's equally toothless in all cases?
Oh, Your Honor, we're not suggesting that this court has applied the same test in all cases. What we're saying is the test of when heightened rational basis review should be triggered according to petitioner's theory is highly problematic. That's the claim that we are making, Your Honor. And in fact...
But you're recognizing that it exists in practice.
Your Honor, we agree with petitioners that this court has likely applied different standards of rational basis review in different cases. Yes, Your Honor.
So then there's more than one form of rational basis review?
Well, according to this court's announced decisions, there is not, but as you would well know, there probably would be differences in terms of the level of rational basis review applied. The point that we are trying to make is that if this court is going to apply heightened rational basis review, it should announce cabining principles so that we know when it should be triggered. And as this court in the Plyler case applied a kind of fundamental right and pseudo-suspect class and put them together, that this court implicitly has suggested in later cases that that kind of formulation for when heightened scrutiny should be triggered is not a legally sound framework.
So do you have principles to argue to us, or is your argument for us to stop doing this?
Oh, Your Honor, I think it's a very difficult question. I think...
well, it's the Ames final.
Well, Your Honor, in terms of when we think heightened rational basis review should be applied, I think what this court should do is really look at its traditional equal protection principles. This court has established when heightened scrutiny should be applied through its traditional inquiry into whether a suspect or a semi-suspect class has been, or the factors that are announced to decide whether a certain group is a suspect or a semi-suspect class. Your Honor, I'd like to...
I thought that we had agreed that there were standards other than rational basis for the suspect class, strict scrutiny for the semi-suspect, heightened scrutiny. So we're asking if there's anything else.
Your Honor, I think this court, many commentators at this law school and other law schools have noted that this court does apply other kinds of standards even though it is announcing that it's applying the rational basis review standard. The point that the State of Ames is making is that if this court is going to announce a heightened, or is going to apply a heightened rational basis review standard, it should announce cabining principles for when that should apply. Your Honor, I would like to go back to Justice Raggi's question
Do you
about...
think there are any for, say, Moreno or Claiborne? What would you're justifying those decisions, so you come up with a rationale better than the one that the court wrote?
Your Honor, I think this, in terms of when heightened rational basis review should be triggered, I think some commentators and some judges believe that these tiers of scrutiny are really ways to think about issues where, if you take a less formalistic approach and you just kind of weigh the interests at stake, these tiers of scrutiny may be hyper-technical. Your Honor, going back to Justice Raggi's question about the same-sex adoptions, I think I'd like to clarify that a little bit. As my co-counsel argued, the fact that we allow same-sex adoptions is logically consistent with the fact that we prohibit same-sex couples from marrying. And Justice Ginsburg noted about this, the ex post versus ex ante. Why don't we think about the children that are actually in these same-sex couples? And what I would draw this Court's attention to, Your Honor, is the case of Dandridge v. Williams. Now, in our particular case, what we're saying is that if there are already children in suboptimal conditions, we're basically doing all we can to help those children without incentivizing ex ante the creation of more children brought up by same-sex couples through methods like assisted reproduction. And the assumption here is that by extending the 700 rights and benefits of marriage to a same-sex couple, that is, in addition, the emotional commitment that comes with marriage, that influences the decision whether to have a child through assisted reproduction.
May I just go back, because I was a little startled that you mentioned Dandridge. Dandridge was a question of the state paying out to support children. And it said 5, or was it, I don't remember the exact number, that's enough. This was the states devoting its resources for families that are having, in the then government's view, too many children. Now, here, nobody's asking the state for any money. These are people who want to live their lives as citizens of the United States and raise children. How can you possibly compare one that involves state funding and the other, if people just say, we want to have equal citizenship, equal dignity, equal respect, we're not asking the state to give us anything except that basic dignity?
Your Honor, there are 2 points I'd like to make. First is, as Justice Raggi pointed out, the marriage statute does extend 700 rights and benefits to married couples, so there is an economic component to extending marriage. The second point is, with respect to the Dandridge case, the point I was trying to make was, in the Dandridge case itself, the court said an AFDC cap was okay in terms of limiting the maximum number that a family could get. And that would hurt the children if those parents decided to have more children, but one of the state's interests was family planning. And it's the same analogy here, where, yes, there are unfortunate effects by not extending marriage to gay couples who adopt, but that is, the legislature has made a reasoned policy choice that it would rather not endure the cost of incentivizing ex ante more births into same-sex couples.
I'm not sure I follow you entirely. You've just acknowledged that there are about 700 benefits that go with marriage. Did I understand that correctly?
That's correct, Your Honor.
And so if Mary marries John, she gets them all. And if Sam marries John, he gets not one. How do you give us a rational basis for that decision, that you get community property rights, you get inheritance rights, you get rights about the spousal privilege? How do all 700 go to one person and not another?
Your Honor, there's 2 points I'd like to make with respect to that question. The first is, with respect to whether each of those 700 laws are grounded on a rational basis, it's a different question from whether this statute furthers this state's legitimate state interests in procreation and childbearing. So what we're talking about now is not the constitutionality of these 700 statutes that are conditioned on marriage, but rather this particular statute as to whether DOMA furthers the state interest in promoting a optimal childbearing environment in a favorable setting for procreation. Your Honor, I'd also like to mention petitioners' claim that DOMA is vastly over-inclusive. They state something like, on page 34 of their brief, that 44.1% of women have undergone sterilization procedures. What they don't tell you is that the overwhelming majority of those women have already had children. So, therefore, the petitioners want this court to think that most women don't intend to have children by entering into marriage.
Before we get into the battle of, you concede that a couple, she's 70, he's 60, they can get married, and that's all right, even though it's quite clear they don't enter into the union to procreate. But you had a rather dramatic heading in your brief: heightened rational basis review does not exist. And then you have a footnote that petitioners, in support of the claim that it does exist, they do not cite a single opinion of this court. Instead, they cite to a law review article by a former staff attorney for the Lambda Legal Defense and Education Fund.
That is correct.
Now, you know that they could have cited you could have cited perhaps the most cited law review article in the history of law reviews, and that's Gerald Gunther's forward to the Harvard Law Review. When was it? In 1971. Would you tell me why you did not refer to that article, instead put in a footnote, this is just a staff attorney for the Lambda Legal Defense?
Your Honor, to confess, I actually, the forward, Gerald Gunther's forward, did not occur to me at the time that we were writing this brief. What did occur to me, Your Honor, was the fact that no majority opinion of the Supreme Court has ever announced such a standard. And that was the point we were trying to emphasize, Your Honor.
I think if you count up the individual justices, you'd get a majority.
That may be the case, Your Honor. Your Honor, there's a few more points that I'd like to address. I know the time is running short. With respect to, again, with respect to petitioners, going back to the argument about sterility, with respect to petitioners' claim that DOMA is vastly over-inclusive, I've demonstrated to you that actually the overwhelming majority of women who enter in marriage both have the intent and the ability to have children. And Your Honor, there's also another state interest at stake, that in raising children in the optimal childbearing environment. So with respect to, say, sterile couples, for example, even though they cannot procreate, many sterile couples still choose to adopt children, and therefore that still rationally furthers the state interest in promoting an optimal setting in childbearing. Your Honor,
Let me ask you, would it be more optimal for a gay man and a heterosexual woman to raise a child as opposed to a same-sex couple who deeply in love with one another and care about one another?
I think what Your Honor is getting at is the statute, as every social policy that's drawn by the legislature, is not perfect. The line is not drawn perfectly. And there may be cases where the optimal childbearing environment may be better in a same-sex household rather than an opposite-sex household. The point, though, is on a general rational basis review standard where the legislature is drawing lines, is this a rational statute? And I would submit to you, Your Honor, that the fact remains, and we haven't really talked about this, but there exist studies showing that children growing up in same-sex households fare worse on some measures than children growing up in opposite-sex households. And for this court to conclude that Ames acted irrationally is to force Ames to ignore these scientific studies and essentially adopt this court's own intuitive policy judgments. And as this court has long recognized, this is not the role of this court to second-guess reasoned legislation. For these reasons, Your Honor, we ask this court to uphold the Ames Defense of Marriage Act and affirm the circuit court below. Thank you, Your Honor.
Thank you, Mr. Liu. Petitioner has rebuttal time of 3 minutes. Mr. Crickbaum.
Thank you, Madam Chief Justice, and may it please the court. DOMA is irrational. It does not increase procreation. It does not put more children in heterosexual households. It does not save money. Instead, it stigmatizes and demeans gay and lesbian couples, and it severely disadvantages their children. The state of Ames admits, as a majority of this court has recognized, that rational basis review is not a uniform standard, and it asks for cabining principles, and they exist in this case. This court performs heightened rational basis review for laws that target a politically unpopular group, severely inhibit their personal relationships, and categorically exclude them from the protection of the laws. That is DOMA, and that is what DOMA does. Now, on the fundamental right to marry, the state of Ames has a single claim, and that claim is there is a traditional right to marry, and it excludes gay and lesbian couples. If this court had applied that analysis in Loving, it would have concluded there is a traditional right to marry, and it excludes interracial couples. Certainly, the traditions at the time of Loving in Virginia and in many other states excluded interracial couples. If this court in Turner had conducted the same reasoning, it would have said there is a traditional right to marry, and it excludes prison inmates. This court did not do that. Rather, in Turner, this court examined marriage. It linked marriage with devotion and intimacy, personal dedication, and emotional support. It said that prison inmates can do that just as well as law-abiding citizens. And in this case, that is not a question.
In all the cases that you've just reviewed for us, the question was which men and which women could marry. You are asking us to change the definition. I mean, you argue that to us in the brief, aren't you? You're asking us to change the definition of marriage to include unions between same-sex individuals.
No more than this court changed the definition of marriage in Loving to include interracial couples. The core of marriage is not the gender of the participants. The core of marriage is the commitment they make to one another. It's not their race.
It became that at one point in time, and after all, marriage was quite a different institution.
Absolutely right, Your Honor, and marriage has changed many times in our nation's history, both because of social changes and because of decisions of this court. What the petitioners
But what's remarkable is all those changes that made marriage more of an equal union than a dominant-subordinate relationship were all legislative acts, the Married Women's Property Acts. The court didn't have any role in that.
Certainly, my time is up, Your Honor, but certainly the court had a role in Loving, the court had a role in Turner, in saying that marriage cannot exclude interracial couples or prisoners, and the same reasoning should apply to this case. Thank you.
Thank you, counsel. The case is submitted, and the court will take a brief recess.
Great brief, guys. Really good job.
Good job. Great job. Great job.
Please be seated. The court has reconvened to announce its decisions. The arguments were so engaging, we wished we could have just cheered all the participants, but it is a court's obligation in the end to decide. And so our first decision is the best oralist, and that prize goes to Mark Crickbaum. And the next decision is the best brief. And we know that that was a team effort. The prize for the best brief goes to the respondents, Mr. Ajami, Ben-Lulu, Block, Liu, Rahman, and Ms. Simpson. And finally, the prize for the best overall performance goes to the respondents. My colleagues, Judge Paez and Judge Raggi, will have a few brief comments.
Thank you, Justice Ginsburg. First, before I say anything, really, I just want to say thank you very much for inviting me to come out to Harvard here and participate in this event. I'm honored to be here. And like Justice Ginsburg said, I wish we could just give a big round of applause for all of you, and we do. But it's hard to draw lines, and we thought long and hard about what we did. Just a few comments about how I, as an appellate court judge, and how I view oral argument, for example, which I put in a different category than the brief writing, because much of what I do as an appellate court judge is to read briefs, and I read a lot of briefs, more than I care to mention. And our argument has a role to play in the decision-making process, but it is not, oftentimes, most of the time, it is not determinative of the outcome. It's the brief writing and the analysis and the discussion of the cases and the facts that tend to be the most persuasive. But oral argument does have value, and I have told people many times that I have been turned around on my assessment of a case by listening to counsel argue and to hear them respond to either my questions or the questions posed by my colleagues. Because oftentimes we use oral argument, one, simply to better understand the record in the particular case, two, test concerns about a particular view we may have of a case, or concerns about how one of our colleagues might be thinking or looking at a case. And we use oral argument to draw out responses and to test our assessment. Here, and in that process, probably the most effective thing for me, from my perspective, is that when counsel are asked a question by a member of the court, that counsel respond, listen to the question, respond to the question, and to the best, as carefully as possible to answer the question, because there's a reason why that question was being asked. And I thought tonight we saw a very good effort by all counsel, although along the way there were some moments when counsel had a difficult time responding to questions posed by one member of the court, or several of us. And you have to be prepared, because you're going to be challenged. You don't know where the question is going to come from. You don't know what's going to be on the mind of a particular judge. And you're going to be challenged. You're going to be forced to think through and to respond instantly with a thoughtful response to the questions the court raises. So my own comments overall, I thought you did a fine job, all of you did a fine job in listening to the questions and in answering the questions and trying to give us your best assessment. I'll save any other comments that I have for you, and the way some of the things you said you might think about doing differently when we get a chance to meet a little bit privately. But I thought it was very good. All of you were just excellent, and it renews my faith in the younger generation of lawyers that are about to replace us. It was very good.
I can only echo all of the compliments that were just paid by Judge Paez. I thought this was a very, very fine performance by both teams, both on paper and orally. And we were so long in conference precisely because it was difficult to make choices here. We'll be able to talk to you more about the briefs in a moment, but I will just say that the respondent's brief is just very well written and very well organized, and the whole team should feel very proud of the efforts that were made. With respect to the oral arguments, they too across the board were very, very fine. I was thinking as you all were arguing that I once heard a former Solicitor General of the United States say that an ideal appellate argument should really be a thoughtful conversation between the advocates and the bench. And I really think that's what you all were able to do. I mean, your styles were uniformly appealing, and your ability to, respond to questions were very, very fine indeed, with special praise, obviously, for Mr. Crickbaum in that. I just want to say what a thrill it is for me to be here. It's taken me 28 years to get to an Ames final. The dean mentioned at dinner. The dean mentioned at dinner that I participated in Ames, but she was so delicate in not mentioning that I didn't make it to the finals. And I mention that because while my warmest congratulations go to the Archibald Cox Memorial Team, my heart is with the Atticus Finch team. And I just want to say that if in the days ahead you find yourself, as I recall, I found myself wandering around convinced that your life is over, remember, there is life after Ames, often on the federal bench.
I have a slightly different experience with the Ames competition. This is the third time I have participated in such a competition. And because I read so many briefs in my everyday job, I had sworn off moot courts. I said no more. But your wonderful new dean called me, and in her inimitable way, without really twisting my arm, asked me to do this. And so I am here because of Dean Alanna Kagan, and I must say it was a treat. I thoroughly enjoyed it. And now the hour is late, so the court looks forward to meeting all the participants shortly, but the court is adjourned.